Good morning, everyone. My name is Ismail Shakhtakhtinsky. I am the principal immigration attorney at IS Law Firm. While on the way to the office, I will tell you briefly about the changes to the asylum claim processing at the U.S. border. So, beginning from May 31st of 2022, the DHS, the Department of Homeland Security, began implementing a new rule for processing asylum claims at the U.S. border. So what has changed? The In the past, once the asylum applicant arrived at the U.S. border, if they surrendered themselves to the U.S. border officer, they would be first detained, then they would go through the credible fear interview, and then once their credible fear interview was positive, if the officer determined that there was a credible fear and the applicant can apply for asylum, then their case would have been transferred to the immigration court for removal proceedings, at which the applicant can request the immigration judge for relief for asylum. Now, what they have changed is that now, once the credible fear is positive, then instead of transferring the case to the immigration court, the USCIS will allow the applicant to apply for asylum affirmatively. So basically, the applicant will go through the asylum interview just as if they were, at the time of application, if they were lawfully present in the U.S. So the difference between affirmative asylum and defensive asylum has always been that in defensive asylum, you will only request asylum in the immigration court. Affirmative is for someone who is currently in the United States who applies for asylum. Then they get a first chance of getting asylum approved through USCIS office at the asylum interview, and then only if the asylum interview they don't pass, then the case would be referred to the immigration court. So now the new change is that the applicants at the U.S. border will be treated the same way, where they can go through the asylum interview first, and only if that does not work, then their case would be referred to the immigration judge. The second change within the same rule is that at the time, if the credible fear review is positive, not only will the case be scheduled for the asylum interview at the asylum office, but also their asylum application would be considered to have been filed. So in the past, a lot of applicants had this issue. When they arrived, they had a credible fear interview, and then they were released, paroled, where they were placed in removal proceedings, which the immigration court removal proceedings didn't start for quite some time, sometimes for 2 or 3 years, and the applicant failed to file their asylum application during that time. Now that has also changed, and during that time, what I mean is within 1 year deadline. Now, what has changed now is that once the credible fear interview result is positive, the asylum application would be deemed as if it's been filed, so that there is going to be no 1 year deadline issue anymore. So hopefully this information and this process, the new process, helps for the new applicants and to streamline the process, the applications, as well as it will hopefully relieve the immigration court from significant backlogs. So not every case is going to be referred to immigration court as it used to be done. Now, this rule has not been fully implemented yet. So they're phasing out this process, and it will gradually be fully implemented, where every asylum applicant at the U.S. border will be given a chance to prove their asylum case affirmatively through the asylum interview, versus having to go through immigration court and removal proceedings. So, good luck to everyone.